Real estate contracts. Do you guys know what a contract is?
Yeah.
What is a contract?
It's a form of documentation that you're writing down.
A form of documentation of writing.
Documentation that you're writing.
Okay.
Stating that you want to purchase something.
So you're trying to tell me that a contract must be written.
Well, technically, it's already written, you just have to fill it in most.
So you're trying to tell me that the only contract that exists
Alright.
is no. The only contracts that exist are written contracts.
Technically, yes.
Technically,
Yeah.
You can have oral contracts as well.
you can have oral contracts. Yeah.
But it's not
For
written,
real
so
estate.
it's technically not.
If I shake your hand and agree, that's what you used to do before,
I
right?
agree with those.
One thing is what you believe, another thing is what it really is. So can we have verbal contracts?
You can.
Do you have rental properties?
No.
Do you rent?
No.
Do you used to rent?
Yes.
Did you have a lease written down or verbal?
Lease.
Do you know of people that have verbal agreements
Yeah.
and that's not a contract? I say I'm gonna pay you X amount every month. It's a contract. You agree to rent to me as long as I pay you X amount every month.
Yeah, but you can go around the ways and say,
What?
I never do anything.
No, that's things that could happen. My question was, what kind of contracts can we have? Because you said written. Okay, can we have verbal? There's a lot of verbal contracts, and we're going to talk about leases later on, because that happens a lot. I would not put a contract verbally. It has to be in writing, because that's where we fine-tune
Mhm.
those ways around. We fine-tune to avoid them, even though there's always a way around. Okay? But contracts can be oral or written, okay? Now, on the right-hand side, it says, contract may be defined as a voluntary agreement between legally competent parties to perform or refrain from performing some legal act supported by legal consideration. So all it is an agreement between two or more parties to do something. And in exchange, there's consideration or value, right? Next page it says, essential elements of a valid contract. There's 4 essential elements of a valid contract. You guys got to know this by heart. 4. That's all you got to remember is 4. One of them, the very first one, is competent parties. When we say competent parties, you're talking about people that are of legal age and of sound mind. And what do we consider legal age?
18 and up.
18 years of age or older, right? So it says to enter into a binding contract in New Jersey, a person must have at least 18 years old and sound mind. What does sound mind mean?
Not drunk. Well,
Not under the influence, not under
That's
duress.
an example.
It's a free voluntary act. I want to do this because I'm clear minded and I want to do this right now. Got it? Drunk.
Sorry that my example
Jeez.
is voluntary.
But yes, the drunk would be one of them, not drunk. Hopefully taking the exam also. Now, it says right there, second sentence, a married person under 18 is considered an adult. So what we're trying to say here is, because then there's a separate sentence. What we're trying to say here is, through emancipation, children the age of 16, 17, they can get married. So emancipation is the parents giving authorization to get the hell out, kind of, right? So you're telling them, hey, you want to be a grown-up? Sure. I'll sign, I'll waive, you're now an adult. The problem is, and that's what the sentence says right here, you're treated, from that moment on, you're treated as an adult. You can never say, well, I was not 18 yet. No, the moment you're married, emancipation occurred, you're treated as an adult. You're tried, as if you go to trial, to court, you're tried as an adult. You got it? And the reason why I stop here is because the next sentence says, persons under 18 may enter into a valid contract, but the contract is voidable by the minor until a reasonable time after he or she reaches the age of 18. So, if I buy a house and I put my son's name on that house with me, my son is 12. When he reaches the age of 18, he can say, no, I don't want real estate, because I mean, which kid follows what the parents do? Right? So he can say, no, real estate's not for me. I don't want that. You know what? Take my name out of there. Can I force him to stay?
No.
No. Can I enforce the contract, go to court and say, Your Honor, it's part, so he has to deal with it? No. Because now he's of age, he's of sound mind, and he can void the contract. So persons under 18 can void contract, except if they're married. All right? Very important to know that. Because they will... Huh? Ja?
Okay, sweet, it's done.
Alright. But this is very important because in the state exam... sorry. Because in the state exam, they trick you. You've been there, right?
Mm-hmm.
So they trick you into these little details. They say married and you didn't pay attention. They say, oh, it's under 18, this and that. Or John is 17, Mary 16, and they're married. But in your mind, you just see the age, and then you go straight to the question that says, what type of contract is this? Does that make sense?
Mm-hmm.
The moment it says married somewhere there, that's it. That's the trigger to know they're tried as an adult. You got it? So it's a matter of paying attention to these little words.
So once they turn 18, I mean, once they're married before 18, and they
Mhm.
emancipate themselves. So
They don't emancipate themselves, the parents emancipate them. But
Parents
yes.
emancipate.
But yes.
Okay. So they're what do you call it? They're 16, they're married,
Mhm.
and they go on, they buy a house.
Mhm.
But at 18, does that last law still apply to the situation?
What do you mean?
The persons under 18 may enter a valid
No.
contract, but the contract
They're
will-
adults.
Okay, so that's it.
The moment you say married,
Mhm.
they're adults.
That's
Forget the underage.
Gotcha.
They became of age. They're responsible. When I say tried as an adult, they're responsible for their own acts at that moment.
Gotcha.
Okay? Correct. Okay? The reason I know the reason why the reason why they say 18 years is what's considered a legal adult. Okay? Legal adult. The moment there's a marriage, they become legal adults. You got it?
Mhm.
That's the key. The next thing you got to remember, it's so important. Offer an acceptance, because if I offer, right, but you don't accept, is this a valid contract?
No.
No, it doesn't matter how many offers I put. If you don't accept, then I cannot force you to anything. Right? And because you didn't accept, you cannot force me later on to anything either. Got it?
Mhm.
Offer acceptance. So it's this requirement, also called mutual assent, means that there must be a meeting of the minds on each term of the contract. Meeting of the minds is we both agree, right?
Yep.
The wording of the contract must express all agreed on terms and must be clearly understood by the parties. So very, very important. Competent parties, we're legal age, right? Sound mind, and we both agree, or all parties agree to the terms, right?
Mhm.
Number 3 is consideration. Consideration. The agreement must be based on good or valuable consideration. Consideration is what the parties promise in the agreement to give to or receive from each other. See, I'll give you my apartment for you to rent in exchange for money, for instance. I'll sell you this house, but instead of paying you commission, right? You're gonna help me sell my house, but instead of paying you commission, I have this car in the garage that's worth way more than your commission. Would you take it? Consideration, legal exchange. It says right there, legal tender or exchange of value or even love and affection. See, when I put my son in the contract, did my son pay me anything? No, but love and affection, right? That was the consideration there. He's part of it. At a wedding, can I gift a house to my son or to my daughters?
Yeah.
I can. Love and affection. You got it?
Mhm.
Or just make them pay for the whole thing. You never know. We'll figure out at that point. Are you guys understand this? So as long as there's an exchange of value somehow, consideration. Remember day one, I said, can you sell your father's house?
Yes.
Yes. Right? Do you need a license to do that? It depends.
Right.
If he's paying you something, giving you something in exchange, then
Yes.
you need a license. Okay? And the last one is legality of the object. So I want you to write somewhere there legal purpose. Legal purpose. So all it says here is that to be valid and enforceable, the contract must not involve a purpose that is illegal or against public policy. So usually my examples in class is very simple. If I give you right now $1 million to sell Coke, can you? Is it enforceable? Is it legal? It depends what kind of Coke, obviously. I know what they were thinking, but thank you, Anthony.
If you give me 1 million, I'll sell Coke.
Coca-Cola. Coca-Cola.
Coca-Cola.
Coca-Cola.
DEA is not so listening.
Right? They just tapped into the camera right now to see what I'm saying. It's not me.
Look, your phone
It's
turned
my
on.
students. Anyway,
I forgot it there's a camera over here.
don't worry. And so is your voice there. Anyway, so Coca-Cola, because that's the type of Coke we're talking about. If I give you $1 million to sell Coca-Cola, right?
Mhm.
Then it's the right kind of Coke, therefore legal purpose. But if it was the other one that Ali wants to sell, this is on camera, for $1 million. If it was the other one, is that legal? I'm glad nobody knows who Ali is, except the DEA tapping right now.
No.
Oh, agent, hi.
Yeah,
Having a lump for you, like don't arrest me.
And some chocolate.
And some chocolates. No, those they can arrest me. I'll take the chocolates with me. By the way, I should put this on camera. This is not Coke. I swear is a legal tender.
It's not bribery.
It's not bribery. All right. So the point is legal purpose. So if I tell you that I'm going to help you, I'm going to give you $1 million to sell Coke. If it's the wrong kind of Coke, I cannot enforce that contract. You cannot enforce that contract. You got it? If it's the right type of Coke and I don't pay you, can you take me to court?
Yes.
Yeah.
Absolutely. If you don't sell it, can I take you to court?
Yes.
Yep.
Absolutely. Does that make sense?
Yes.
So 4 essential elements. This is so important you guys understand. Competent parties, we're of age and sound mind, so free voluntary act, right? Offer and acceptance. That means we agree to all the terms of this exchange, whatever contract it is. And then the actual exchange, which is called consideration. And finally, a legal purpose. You got to remember these 4. Does it say signature anywhere?
No.
So is a signature needed in order to make the contract valid?
No.
No, because if it's a verbal contract,
Mhm.
where are we going to sign? Does that make sense? Again, very important because the way they ask questions in the state exam will trick you into that. They'll put a signature when they say clearly in the question, they say clearly that it was an oral agreement. But they put signature as a required element. Does that make sense?
Yeah.
So if it's oral, do we need a signature?
No.
No. Read carefully the questions and you'll pass. Guaranteed. As long as you read.
No, really, read.
Huh?
Really, read.
Read.
It's like,
You can interrupt, it's okay. Now, a valid contract. Oh, look, Patty, what does it say?
What?
A valid contract
Maybe oral or written.
may be oral or written. Parole evidence rule, however, states that the written contract takes precedence over all agreements or promises. Now, Anthony, because you said Coca-Cola, right?
mhm.
Right? The $1 million I'm going to give you was a verbal agreement, wasn't it?
Yes.
But now you're so excited you're about to make $1 million off of this contract that you don't even realize that when I put it on paper, I missed a 0.
Mhm.
And he's so excited because he sees a bunch of zeros there. He's just not really paying attention. He signs. The moment you sign that contract, how much do I owe you?
What you wrote in the contract.
I know math is difficult, but it's 100,000. Yes.
100,000.
Whatever. That was a great answer. Whatever you wrote on the contract.
Because I couldn't do the math quick enough. So I was like, you know what? I'm just going to go with this number.
It's 1 less 0, man. All right.
100,000.
100,000. But you're right. The correct answer is whatever's on the contract, actually.
Yeah.
All right?
You said $1, $1.
That's it. If it says $1, it's $1. If you don't pay
I wouldn't
attention,
realize that one.
you wouldn't realize, right?
No, with that one I wouldn't realize.
You would?
Like, whoa,
If it's
$1?
$1?
Yeah. Like, whoa,
What if I put 1 and then I write 0 next to it, like 1 and zeros? O's. No? Okay. Anyway, so the point is, I actually gave you 100,000 per contract, but our agreement, original agreement, was $1 million. How much are you short?
900,000.
Thank you, Patty, for your help. 900,000. Pedro, you don't need to do the math. He's on the calculator.
I just see that you're right.
Guys, you're gonna do great in the exam because there's only 6 math questions, max 8.
Yeah.
So you're gonna do great. Don't worry. And we have a math chapter at the end.
And they give you a
And we
calculator.
use a calculator.
And we use calculators. The problem is knowing when to do x or when to do division or subtract and all that.
Oh, gosh.
Well, you couldn't subtract to 0, so you don't know. Yeah.
We don't realize too, zero.
All right. So I'm just joking around, but here's the thing. What happens to the 900,000? Can you come after the 900,000? No?
I can try.
Oh, you can always try. The question is,
Will I get it?
will you get it? What if I told you there's a way you can get it?
Then I would like to know it.
Of course, right?
Yeah.
So here's the thing. First of all, statute of frauds. New Jersey statute of frauds states that a contract for the sale of real estate and any lease for more than 3 years must be in writing. Underlined, must be in writing. And signed in order to be enforceable. So if it's a contract for the sale of real estate, must be in writing. If it's a lease with more than 3 years, must be in writing and signed by all parties, right? But to every rule, there's what? An exception. So in 1996, New Jersey statute of frauds was changed so that it also allowed oral contracts to be enforced where there was clear and convincing evidence that the buyer and seller had agreed orally on the exact real estate to be transferred, the nature of the interest to be transferred, and on top, the existence of the agreement and the identity of the transferee. So if it's a verbal agreement that we made, me and you, right?
Mm-hmm.
As long as you got clear and convincing evidence, right?
Yeah.
Like witnesses.
Yeah.
He's not valid because he was outside, but you got witnesses, right? Bring him to court. Is there an exchange or any type of communication between us that would indicate that we agreed? Does that make sense?
Mm-hmm.
Yeah.
So, clear and convincing evidence will still enforce the contract. You got it?
Gotcha.
So in writing, we put 100,000. Verbally was $1 million. If you want to come after 900, you need something that proves or kind of shows that my intention was to pay you $1 million. Okay? Questions here? Self-explanatory. Okay. Just make sure, first of all, there's no dumb questions. Let's start with that. Second, ask questions. Interrupt the class if you have to. I just want to make sure you guys are getting it because the video is great to watch at home, but here I can explain more. Does that make sense?
Mhm.
And unfortunately, the question that's not asked is also never answered. Okay? That was like,
That's
Right?
mind blow.
that was mind blowing, right? It was like Kung Fu Master type of thing. So right above types of contracts it says, the real estate broker's authorization must be in writing and signed for either a sale or lease transaction, whether the broker is acting on behalf of the seller, the buyer, the landlord, or the tenants. So, if we're part of it, then there's no verbal. It has to be in writing. You guys remember that from listings as well? Our authorization must be in writing to sell somebody's home. Great. Now, there's different types of contracts. There's expressed or implied contracts. There's unilateral or bilateral contracts. Executory or executed. Valid, unenforceable, voidable, or void. So let's start with expressed and implied contracts. It's very, very simple. Express contract. You have to be here for 75 hours. I'm expressing that for you to get your license, you need to be in a classroom for 75 hours. It's expressed. Does that make sense?
Mhm.
You have to pass the state exam. We express that. Right? Okay. You have to pay certain fees. It's expressed. So anything that's stated, whether verbally, because a lot of people think it's in writing, whether verbally or in writing, if it's expressed like that, then it's an express contract. Implied is that for you to learn, you have to pay attention. Right? For you to learn, you have to study. Yes?
Yep.
And for you to learn, you have to be here. Simple. These are implied things. So expressed over there is the 75 hours, the passing a state exam, the paying for fees. That is expressed. It was given to you as already has a lineup of things to do, right?
Mhm.
Implied is what is expected to happen. Yes?
Yes.
Good? Questions? Then we have bilateral and unilateral contracts. Lateral means side. So if it's bilateral, then it's a two-sided agreement. If it's unilateral, it's one-sided agreement. So what does that mean? One-sided means you got to do something in order for me to do something else. A bilateral agreement is two-sided, means that both parties must do something to complete the transaction. So that's what we have there. In a bilateral contract, both parties promise to do something. One promise is given in exchange of another. So seller promises to sell, buyer promises to buy, and both must take positive actions towards the consummation of the transaction, right?
Mhm.
Can the buyer just wait for the seller to finish their side? No, they concurrently work to get there, right? A unilateral contract says it's a one-sided agreement whereby one party makes a promise to induce the second party to do something. The second party is not legally obligated to act. However, if the second party does not comply, the first party is obligated to keep the promise. And the example we have here is those crime watch signs. If you see a crime, say something, right? If you see something, say something. And there's a $10,000 reward, as an example. Are you going to call the cops and say, I'm about to witness a crime?
No.
No. I mean, you can. Hey, I think it's about to happen. But can you say, I'm about to witness a crime, where's my 10K? They're not going to pay you until you give the complete information of what just happened, right?
And they cut that.
So the point is, the police doesn't have to pay you until you actually witness a crime and reported the crime. So pretty much what we're saying, and you have that on the next page. I will do this if you'll do that. So I only have to reward you once you found, you witnessed the crime, pretty much.
So, how does that
Yes.
how is that played out in real estate?
Decline?
No.
Well, I cannot tell you that on camera, but off the record. No, I'm just kidding. It doesn't play out in real estate. We're talking about contracts in general.
Okay.
This right here is contract law.
Okay.
Okay?
Mhm.
So,
I was just wondering if there is a situation where something like that would occur. Basically.
well, most of the times, it's verbal agreements. I'm going to do something, you're going to do something. But, for instance, a buyer, they don't pay you, right?
Mhm.
But if they agree to pay, if there's no contract with the seller and they agree to pay you, they only pay if you find a property, right?
Gotcha.
The seller, usually we have a listing agreement, so it's different. There's already a compromise there to both parties do kind of something.
Mhm.
Until recently, I used to use actually the listing agreement as a unilateral contract because you don't get paid until you bring a ready, willing, and able buyer. But the concept of being already in agreement and the seller has to participate in certain things,
Mhm.
like showing the house and all that stuff, then it makes it a bilateral agreement.
Oh, yeah.
Okay? So that I'll admit it was something that I was disclosing in a different way. It was incorrect. The basis of it is still the same. You only get paid if you find a ready, willing buyer. So the moment there's an if there, the concept should be the same. But because the both parties do something, me as a realtor, the seller as a seller, we both have to do something to make this happen, right? It's implied. Yeah. There you go. Hey, at least I admit my mistakes.
No, that's fine.
Everybody
Yeah.
has this.
That's why I wanted to understand it more, like if there is
Yep.
a situation, but apparently,
Yeah.
at one point there is, and
Yeah.
another point there's not.
All right, next we have executed and executory contracts. Executed and executory contracts. Now, have you ever heard of execution before? What does that mean? All for the head, right?
Mhm.
Done. So execution is ending something. You got it? So if it's an executed contract, what do you think just happened?
Done.
Closing. We're done. Now, executory means something is pending. Okay?
Mhm.
Executory means something is pending. So when we put a contract, can you tell me more or less how many days, student, please? Student in the front. Can you tell me how many days do you put in the contract from the moment you sign to that potential closing date? How many days more or less? On average?
30 to 60 days.
You put in the contract 30 to 60 days to close?
Put the dates.
To close? 45 days later?
Mhm.
Okay.
Depends.
It depends.
to be, 45 to 60, that's what I'm saying.
Okay.
If,
Contracts usually
if I
take
know the
3.
mortgage guy very well and they tell me that's very, very good setup.
Alright.
So I go 45 days because the sellers like to see it, sometimes like to see the faster closing.
Yeah, one thing's seeing and
Even
another thing is
though that-
happening.
Even though that sometimes not happen, but
So what I like
you
to
ask me
say,
what I put there.
no, I know.
Okay.
What I like to say is 90 days, because the average closing takes 3 to 4 months, depending on the type of financing you're getting, right? And inspections and people participating. So you got to have a very good. In today's market is a little different, but you got to have a very good relationship with your parties, and putting enough pressure for things to happen. But set yourself up, especially because in the beginning, you're gonna make mistakes. That's guaranteed. In the middle, you're gonna make mistakes. That's guaranteed. At the end, you still make mistakes. We always make mistakes. That's human, right? So just prepare yourself in your mindset, because a lot of people say, "Oh, I sold," and they're ready to close tomorrow, and then tomorrow comes and we don't close. There's a delay. There's whatever, and then it goes another month. Goes another 2 months, and then the deal dies. So it's preferable that you put in your mind like 90 days, right? If it closes sooner, great, right? But let's say 90 days. So we put a contract today, and only 90 days later do we close. During this period of time, this particular contract of sale is executory because there's stuff pending along the way. What is pending? Attorney review, inspections, the mortgage commitment, all that title reports. These things are pending to happen before we close. Good? Once we get to the closing table, again, and everything is in order, we exchange keys, the check, closed, executed. Got it?
Mm-hmm.
Questions?
So executory, from the moment the contract is submitted to the seller,
Mm-hmm.
from there on in, it's considered as executory.
It's not even a valid contract yet. The moment it's signed by the seller,
Okay, the moment it's signed by the seller.
then it's a contract.
Okay, yeah.
Because if I put an offer and there's no acceptance, is that a contract?
No.
Okay. You see where it ties in now?
Mhm.
There's an offer, but there's no acceptance. It's not a contract yet. There must be offer and acceptance. Cool. Now it says validity of contracts. A contract can be described as valid, void, voidable, or unenforceable. Now, depending on the circumstances. A valid contract, for instance, contains all essential elements and is binding on and enforceable by both parties. Who can tell me what are the 4 essential elements of a valid contract?
Competence.
Competent parties.
Competent parties. Just went over it.
We just went over them,
I
yeah.
know. I'm trying to remember. Competent parties was one where everyone's of age.
Mm-hmm.
The other one was offer and acceptance, and then we have. My brain is about to explode because I just read them over.
Anybody else? Ah, see?
I'm trying to avoid looking.
From
back.
one page to the other, you see what I was telling you earlier?
Yeah.
Okay.
Consideration.
Consideration
Skip this here.
and Coke.
Legal purpose.
Legal purpose, you see? It's dumb examples, but they work.
Yeah.
All right? So when you're taking the exam, just think of Coke. It might help you pass too.
Wait.
Right? All right. So here's the thing. I always do this in every class. From back here. Okay. So I do this in every class that I teach. Is to show you again the power of studying at home, of reviewing everything. Because you just went from one page to the other, blank. Something that I actually slowed down and explained a bunch of times. Competent parties. We talked about being legal, adult, and of sound mind. We talked about emancipation, about minors being involved in contracts and being voidable, right?
Mm-hmm.
Didn't we just talk about that?
Yeah.
We talked about offer and acceptance. If I put an offer and you don't accept, then it's not a contract, right? We talked about consideration, exchange of value. We even talked about love and affection as being an exchange of value. Not too long ago. But I understand. He got up and distracted everybody. So that's why there's a blank. Yeah.
I blame him.
That's it. If you fail the exam, come after him. No, the point is, again, just review everything. It's so important that you review it. I'm here just dumping info, right? And it's like going to the gym. You got to do what I like, which is high intensity interval training. Like you go at it and then you rest. You go at it and then you rest. It's not like being there for 10 hours at the gym, because that doesn't do anything for your muscles. They get used to it. They don't receive any more information. Does that make sense? But you got to interrupt the pattern, and that's what high intensity break means. Studying is the same thing. Here I'm just dumping info and I give you that little break. But when you go home, you should take 15 to 20 minutes to review everything. Not like 3 hours studying, because that doesn't work. Guaranteed, it doesn't work. Your brain starts wandering, you go everywhere else but what you're studying. Got it? Very important. Void contract. What do you think a void contract is? If a valid contract contains all 4 essential elements, what do you think a void contract is? It doesn't have the essential elements. Period. A voidable contract. Voidable, I mentioned minor, right? Once they reach of age, what can they do? Void the contract. Unenforceable contract at the bottom. Also seems on the surface to be valid, so it appears to be valid. However, neither party can successfully sue the other to force performance. An unenforceable contract is said to be valid as between the parties, because if both desire to go through with it, they can do so. So what we're saying here, and you can go to the right-hand side on top. I'll give you the example right now. We're saying here that the contract is valid as between the parties. So, do you want to go for a drink later?
No.
You're down. You're always down for it, right? So we're going to go for drinks. And as we're having drinks, we're talking about the only thing we have in common right now, which is real estate, as an example, right? I mean, we already know got kids, but let's say I didn't know that's what we're talking about. Talk about real estate first. You got to build rapport, and that brings everything else. The kids, the instructing, all that stuff. But we're talking about real estate. And then I'm telling him, over drinks, I'm telling him that we have a property listed, right? It's a 4-family for $200,000. It's a cash cow. It's an amazing deal. He's getting into the real estate thing. He gets all hyped up, and what does he say?
I buy.
I'll buy. He has not even 1 cent in his pocket, but I buy. Checking account is 0. So 1 cent in the pocket, checking account is 0 is tough.
He doesn't know you're buying beers.
Oh, I'm paying for it? Oh, damn it. So the point is, we're talking about something that's a contract, and we enter into a contract right there and then. Because nowadays, I told you, got a phone, tablet, got the computer, we can e-sign everything, right? So, we're having drinks, you say you want it, you'll buy it. So, hey, let's prepare the contract right now. Done. Next day, he wakes up with a huge headache. What is that called? No. It's called buyer's remorse. Hangover.
Hangover, wait, I thought it said hangover, and I was like, remorse.
You know, 99.9% of the times, everybody falls for that one.
Really?
Hangover.
I mean, you're talking
You
about
talk about the
beers.
beers.
Not gonna forget it.
I do it on purpose.
Oh, yeah, I'm gonna
I
do
lead to that. So buyer's remorse. Why buyer's remorse? 1, he can't afford a house, for instance. 2, he was not in his right state of mind. What did I do? I signed a contract. I didn't even consult with my wife. I'm getting divorced after this. Right? Because she's the decision maker, not you.
Then I-
Right? Uh-huh.
Cash cows.
He was a cash cow.
Amazing.
Uh-huh. That's what I said over drinks. Actually, that's what he heard over drinks after a few, you know. And that's the thing. Can I sue him and say, no, now you're buying. I'm going to force you to buy. Can I sue him?
No.
Why not?
Oh,
Falls
it's
under
like
one of these categories?
incompetence.
He was not of sound mind. Therefore, he was not a competent party. If there's no competent party, then there's no valid contract, right? Now, what we're saying here is that if he woke up next day all happy, I just signed a contract for an amazing deal at Cash Cow, my wife is all happy about it too, can we move forward?
Yeah.
Yeah, so now it's valid between the parties. It says the contract is valid between the parties. Because we both agreed to move on. You guys got it?
Yeah.
So if he was unhappy with the situation, we don't proceed. If he liked the deal and wants to proceed the next day, we move forward. So it's unenforceable, but it's also valid. Okay? between the parties. If we agree to proceed, we will.
And that's the question.
Really? I don't know why I stop at these particular points. Have you noticed?
Yeah.
So with the amount of times you said that was on the test,
I think I've reached 120 questions already.
we're probably close to the 110 questions actually. Still have a few to go.
Yeah, we'll get there.
We'll get there.
I'm almost 100% sure.
So you guys should mark down like stars every time he says it's on the test. Just put something there.
I write it all over my paper. I'm like, I'm remember this now.
Test. Test. All right.
Star.
We already covered this right here, undue influence and duress. So contracts signed by a person under duress, that means force, being forced to do something, or under the influence, that means being taken advantage of, are voidable, means may be canceled by such person or by a court. Underline this, put a star, because extreme care should be taken when one or more of the parties to a contract is elderly, sick, in great distress, or under the influence of drugs or alcohol. Highlight, underline, put stars, put bubbles, whatever you got to put here. But to be valid, every contract must be signed as the free and voluntary act of each party. Free voluntary act. Good? Questions before I move forward? No? Performance of contract. Do you see something in bold there that says time is of the essence? Okay. Remember I said earlier that we usually have like 90 days in his contracts, 45, 60 days, whatever, but I told you 90 days to put as a standard in this example. So we didn't just put 90 days, we put an exact date, which is a tentative closing date. So we're saying, hey, on June whatever, particular date, the 15th, for instance, we expect to close. On or about June 15th, we expect to close. Good?
Yeah.
Here's the thing. We're a week away from June 15th. And the seller still did not get the CO. You guys know what a CO is? Certificate of occupancy, right? So the seller still did not get a CO. As an example, it could be something else, but for this example. You bought property, so do you know how long does it take to get a CO, more or less?
Depends what town.
Is it 1 week?
Things like 10 to 15 days.
10 to 15 days is not a week.
I mean, 5 to
If
10,
you do
15
the
days.
Newland, it's less than.
I don't remember.
What
It
is it?
depends on what
The
town.
Newland is less than a week.
Denellen. You never know how to say that town's
No,
name.
That's okay.
So that's a good thing. To do business, you don't need to know how to pronounce them.
Just know they bring money.
It depends
Just
on
bring money.
Bring money.
the town. Mine took 2 weeks.
2 weeks on average.
If it's in Newark, it's 1.5 to 2 months.
3 weeks, no. But let's say, okay, let's say we're a week away. Do you think we're going to close? No, because there's still a CO pending, so we're not going to close. If the buyer really needs to buy, then the buyer's attorney is issuing a time is of the essence letter. And that time is of the essence letter says to the other party, hey, we're supposed to close on June 15th. You are the guys that are at fault. Like your side, you're at fault. We're June 15th and you still don't have what you promised to have before this date. Good so far?
Yeah.
So I'm going to give you an opportunity by extending, so it's like a courtesy, extending the period of time another week or whatever. But after that, my client reserves the right to cancel the contract with no consequences. Does that make sense? So time is of the essence is really saying, hey, there was a question on the test. Okay. So, guys, there was a question on the test. Anyway, what I'm trying to say is time is of the essence. Come on, chop, chop, hurry up. Let's get this done. If not, I'm walking away.
It's like giving you a grace period.
Pretty much a grace period. You can put it that way, a grace period.
But at the time of writing up the contract, the time of the essence can be also put into the contract, right?
Absolutely. You should. It should be. Especially if you're trying to push for 45-day closings.
Oh man, over here pushing.
Still there. Anyway. Dunellen. It doesn't matter. It doesn't matter how you pronounce it. Somebody asked me not too long ago, do we need to know English? No.
Enough to pass the test.
Enough to pass a test, and then the rest is you and your people. Let's get it done. You can make money in whatever language you want. Money is money. All right?
International.
Money's international, yeah. Amen to that, right? All right. Assignment and novation. Anthony, you know, after those drinks, you agreed to proceed the next day, right? I always tie in the stories, right? So you agreed to proceed the next day. But then 2 weeks later, something happened to you and you realized you cannot purchase the house. But 2 weeks later, it's binding. It's a contract that's binding, meaning you have to purchase unless you have a legal excuse. But something happened, personal, right? Not a legal excuse not to buy. So can you back out of the deal?
I feel like there is a way.
Can you back out of the deal?
Yes.
How?
If you are able to assign it.
Oh, because I
somebody
said
else.
assignment and novation?
Well, no. Well, I mean, you can. You can. As long as you can assign it to somebody else, or
If the contract allows,
if the contract allows.
okay, the contract must allow assignment. Okay, that's one of the things. Or the party must agree to assignment. What is an assignment? Flipping paper. Instead of you buying, he buys. So you're going to find him and say, hey, would you... the monkey. No, pass the monkey. Not my monkey. Okay, got it.
Of
So-
course.
You find somebody else to take over your responsibility or liability, right?
Mhm.
So now he's the one responsible for buying. You get it?
Yeah.
It's called an assignment of parties in this case. So now I, as a seller, must agree to sell to him. Because if our contract does not say assignments are okay or something like that,
Mhm.
then I must agree in writing for this assignment. Good so far?
Yes.
All right, cool. In case of assignment, says right there, highlighted, put stars. The assignor, Anthony in this case, the assignor maintains secondary liability if the assignee, Pedro, breaches the contract. So if he does not buy, guess what? You're still liable. So I can sue both of you. You for not buying and you for not buying the first time and giving to a person that doesn't buy. All right? And this right here, you ever heard of those those things that those seminars that they make, flip this town, stuff
Yeah.
like that, right?
Mhm.
So I don't say the exact, exact stuff, right? And those fortune guys, you know, they're actually great. I actually like what they teach and how they teach. The problem is, just like here, it's overwhelming in information, right? In a 3-day event, it's impossible to keep everybody at bay with what they say. So when they talk about assignments, they talk it briefly, right? And one of the things that they explain briefly is that the assignment should be made to a cash buyer, somebody that can actually say, make a decision, I'm buying. Because if you're assigning to somebody that still needs to qualify for a mortgage, what if they don't qualify? See, the lesser risk is find somebody that's a cash buyer. That's the lesser risk, and flips happen like that. Does that make sense?
Yes.
That's one of the problems. And I'm saying this because you guys are going to deal with a bunch of properties like this, right? And recently we had a huge flow of investor market, right? Not regular buyers or regular sellers, but investors. And now they're trying to unload these properties that they got themselves into. And guess who's going to be there to help them? Sometimes us. You got it? And if we're there, we have to understand what just happened and how they got stuck. Okay? Now, Anthony, do you want that liability? Do you want to be always on the lookout to see if he actually buys or not? You thought you were freed, right?
Mhm.
You don't want this liability. So there's something called novation. You see it right there, it's in bold. Novation. It's not a new clause, it's a brand new contract because
Oh.
nova means new.
Mhm.
Novation is a brand new contract, is where I agree, Anthony, to take you out completely and prepare a brand new contract between the two new parties, seller, buyer. Does that make sense?
Yes.
So novation, brand new parties, and this is called novation of the parties. Can we have a brand new contract between you and I, Anthony, and just change the terms,
Yeah.
If both. If both.
values and all that? Yeah, that's called novation of the terms. In this case, novation of the parties is substitution of the parties. Good? It says, in case of novation, please highlight, underline, put stars. In case of novation, the old contract between the both of us no longer has any force. Make sure you underline that. No longer has any force. So I cannot go after you if he does not buy. Okay? So assignment, think of this. Assignment, I can go after Anthony. Still. Novation, I cannot go after him because I created a brand new contract. Okay?
If in the contract it doesn't say that,
I didn't say it was question time. I'm just kidding. Go ahead.
if in the new, if in the.
I'm very rude to my students.
If in the,
That's why they love me. You trying to say something, Shingles?
I'm trying to shingle my way in there, man.
Shingle or shimmy?
If in the contract it doesn't say anything about assignment is possible,
Okay.
do you have to have a novation that's stating that
No,
there's?
you're bound by it. And I can sue you for not buying.
Okay.
That actually just happened recently with a property right here on the street.
Mm-hmm.
I can sue you for attempting to breach a contract, which is what we're going to talk about now. Okay? So if it doesn't say assignments,
Mm-hmm.
from there on is up to me to allow that to happen or not. If it says assignments are okay, then you don't need me to make that assignment.
But when you're asking, if I ask you, can I assign this to somebody else?
If we agree,
Yeah,
then yes, we're going to make
a novation?
no, we make
Okay,
an
that's what I'm
assignment.
asking. Okay.
Novation is brand new contract. An assignment is we're going to initial on the contract that your name is off, his name is on, for instance. But it's the same contract. We didn't change a contract. We agreed that the new person buy. It could be an addendum. It could be our attorneys preparing an addendum to the contract that says new parties to the contract or exchange or change of parties in the contract. But the contract is the same. So you still have the liability, right?
Mhm.
Novation is I completely rip your contract and it's me and him alone.
Gotcha.
Got it? Next page we have default or breach of contract. So we were just talking about this right now. A breach of contract is a violation of any of the terms and conditions of a contract without legal excuse. So I told you that you can't assign, you can't back out, you can't do anything unless you have a very good excuse. What would be a legal excuse, for instance?
You're bankrupt.
You're bankrupt. Oh yeah, it could be. What else? You die. You're no longer a competent party. Right? Does that make sense?
Uh-huh.
Those would be legal excuses. But you falling off your bed and I'm not selling today.
Fine.
Is that a legal excuse?
No.
I'm not selling anymore?
It's just an excuse.
Or I'm not buying anymore? It's just an excuse. It's not legal. It's an excuse.
We're finding something wrong with the property where you're gonna have to now pay more to get
Well,
things
yeah.
before. Okay.
Yeah, that happens a lot. It's called inspections.
Mhm.
And if I find something, see, we have 3 days, 3 business days. We're going to talk about that again. But we have 3 business days to review the contract and the terms of the contract. But then we have inspection period. Inspection period. So the last part of this chapter is contingencies. Inspection period is a contingency, meaning I'll keep on with the interest of buying if nothing pops up. If there's so much damage to the property that will affect my ability to maintain the property at this value, I can legally back out. In fact, I don't have to give you an excuse. I don't agree with the inspection. Simple. I saw it. There's scratches on the wall. I don't want this wall. Thus, I don't want this house. All right. Obviously, they're going to fight it, but it's as simple as that. I'm not happy with the report, so I'm not buying. It's still within it's a contingency. Okay? It says satisfactory report. It doesn't say satisfactory to who. You got it? So, if the seller defaults, meaning the seller does not sell, the buyer has 3 alternatives. The buyer can do 3 things. 1, they can rescind or cancel the contract and recover the earnest money deposit. 2, the buyer may file a court suit known as an action for specific performance. That means to force the seller to perform the contract, meaning convey or transfer the property. So I'm going to sue you to actually sell, right? Or 3, the buyer may sue the seller for compensatory damages. Compensation. Here's the thing. You wasted my time. I took money from my 401k and I'm paying penalties on it. Whatever it is. I'm suing you for up to 3 times my damage. I sold my house in order to buy yours and now you backed out. I have nowhere to go. So now, hotel, for instance. Does that make sense?
Yeah.
So I'm going to sue for compensation. What if it's the buyer the one that says, hey, I don't want to buy anymore? See, the seller has the same 3 alternatives, the same 3, compensation and all that. But they have one more, which is this one. The seller may declare the contract forfeited, and the right to forfeit may be provided for in the contract, and according to the terms of the contract, the seller may be entitled to retain the earnest money and all payments received from the buyer as liquidated damages. I want you to underline liquidated damages, and you're going to write settlement. Because a liquidation is like we're closing. We're done, right?
Yeah.
So it's like you either get one or the other. If you settled for keeping the deposit, right? In rentals, this happens a lot, right? Where the landlord just keeps a secure deposit, right? Because of damages or whatever. So they keep the secure deposit. In this case, when you put an offer, you usually put money with that offer. It's a good faith, which we'll talk about in a second. It's a good faith, hey, I really want to buy your house. Once we agree to everything, a couple days later, we put more money. Again, good faith that I'm going to buy your house, right? We still did not close. If we close, that money is applied towards the sale, right? If we don't close, that money is supposed to be returned to me as a buyer. But if I acted in bad faith, where I'm backing out of the deal, the seller is entitled to keep the money. Do you guys understand? And that's why we put money. We don't have to. By law, we don't have to. I'm going to talk about that in a second. But it's customary that if you want to show that you're for real, that you really want to buy a house, you put up some money. Okay? This way the seller says, all right, why would I sell to that person that didn't give me money? Let me focus on the one that put an offer with the secure deposit. Okay? Good? Questions? Good so far?
Once they settle, they can't go after anymore.
That's the thing. If we settled for keeping that money, I cannot sue you for more. That's what liquidated damages means. We'll settle here. I cannot sue you for more money than what I've taken. Okay? We're going to highlight that in a second too. Mark that in a second. All right. Statute of Limitations. Do you guys know what statute of limitations mean? There's a limitation on suing. So I can only sue you within this time period. Beyond that, I cannot sue you anymore. And we spoke about this several times. What was
6
it?
months, right?
6
It's a
years.
6
Years.
Oh,
years. 6 years. I know what you're thinking. You're right.
Something like that. So you have the period you need to sue the
6 years.
That's why you have to keep all the information, the contract, everything.
Perfect.
For 6 years.
Yes. So that's why for 6 years we got to keep permanent records. Perfect. She's all happy. It's like him the other day. I got one answer right. All right. You know I have that on video, right?
Yeah?
Yeah.
Hope it doesn't make it to the crowd.
I think it's there.
Oh no.
Yes, he said it. All right. So here's the thing. After the 6 years, you can't do anything. But within the 6 years, it's contract law. Any contract, you got 6 years to sue. Unless there's another limitation on the contract itself. Okay? Next we have contracts used in real estate business. We already spoke about this in the previous chapter with preparation of documents. New Jersey allows brokers or the agents to complete residential leases and standard approved sales contracts on 1 to 4 family and single vacant lots. If it's a 5 unit, right, 5 family, or if it's a commercial setting or industrial or anything, do we prepare contracts?
No.
No, attorneys do. What we prepare is called a letter of intent. Right? So it says right there that we may not, make sure you put a circle where it says may not, draft commercial leases, option agreements, or sales contracts on tracts of vacant land, commercial property, or industrial property. We can only prepare on 1 to 4. Okay? 1 to 4. Other states might be different. This is New Jersey, so 1 to 4. Next, New Jersey requirements. It says all offers, contracts, or leases prepared by licensees must indicate the business relationship that a firm has with respect to the parties named in the document. Do you guys remember? You remember CIS? That's what I was going to say. If you remember which document discloses the types of business relationships we can enter into, and that document is?
CIS.
CIS. What is a CIS?
Consumer.
I didn't ask what it means. I asked what it is.
Oh.
You fell for the same thing the other day.
No, I didn't.
No, the other
Oh,
day you did.
yeah.
I thought we were picking on her now. It's where
What
the doc.
agents, right?
You
Yeah.
too. It's just like I was not picking on you this
So
time.
you're
Okay,
buyer's
just
agent,
kidding.
seller agent,
Buyer's
dual
agent.
agent, and that's the last one.
Dual agency is illegal.
Wait, then what's the other one? I know there's four.
Yeah, but dual agency is illegal
Is it? Yeah,
Mhm.
that's right.
if it's undisclosed.
Um,
So you got to say disclosed dual agency.
Disclosed.
Both parties agree to this. Okay, very very important. One word. Actually, I'll show you. One letter can change the meaning of everything. Ready? What's the difference between fee and free? What's the difference between fee?
A fee is something that you charge, and free is free.
What is the difference between fee and free?
The R.
The R.
Oh, I thought you meant like what's the.
That's exactly what I meant. Because if you don't read it right,
This guy's like the Riddler.
I am. Because so is the exam.
I know.
If you don't read it right, you're going to see free, reading fast, and it's actually fee. One letter could change the whole meaning of the question. That's my point. So undisclosed dual agency, illegal. Disclosed dual agency, legal. So yes, you have seller's agents, buyer's agent, disclosed dual agents, and transaction broker.
There you go.
Got it? And you can write there page 34 and page 35.
They must read me.
No, it says please read me, not must read me. I am.
No, but on the
I'm a
test,
Virgo,
but
remember?
On the test, it's very technical, so yeah. That's why I catch it. Free, fee.
Yes.
The R, man.
It's the R. Still took you a while, but anyway.
Yeah.
I'll give you a discount. You got the
Yes.
shingles. Anyway,
What more like it?
so, but the CIS is a disclosure, and that's what I wanted to get at. It's a disclosure. It's not a contract. With the actual contract, there's an additional document, the very first page that's added to the contract. It's called option 26. It's not an option. You have to have it there. It has to be there. And now what we're saying is, with the CIS, it's like, hey, if I represent you, this is how I could represent you. Option 26, the very first page, is now I'm representing you, and this is how I'm representing you. Now I am the seller's agent. Back then, CIS is, hey, I could represent you as a seller's agent, as a buyer's agent, disclosal agent, so on. Option 26 is, now this is how I'm representing you in the transaction. I am your agent, or I'm both agent, or just a transaction. Does that make sense? Cool.
Wait, so when do you present it with option 26?
At the time of contract. But it's not a question of option 26. It's just that with the contract, there must be a disclosure of how you represent them. CIS is how I could represent you.
But you can give them both at the same time? No,
No, CIS is before.
right at the beginning.
Before.
As soon as we start talking about
As soon as there's any
interest.
interest in buying or selling or financial motivation, stuff like that. Okay? It's the very first thing that comes out of our mouths is, hey, I could represent you like this, or represent you like that, or not represent you. Legally, that's what it's supposed to be.
And then you get an idea.
You heard the,
No, it's something.
yeah.
Honey, can we get
It's the backdated document.
It's the brain.
I cannot let the person today actually put it.
With every single property? You're amazing, man.
I am.
You're a super agent.
I am.
And the buyers are super buyers because they're really
They
interested.
are.
And the sellers,
Especially my
on
buyers
point.
and my sellers. Oh yeah, they're just boom boom.
Think about it. Every single time you meet a person, that person puts a contract the same day. How many times did it take you before you decided on the house?
Well,
Like a lot. What, you saw 10 houses?
yeah.
Okay, so you're my kind of buyer. Did you see like 30 houses?
No, about every 10 houses I put in a contract.
No, I
No, I swear to God.
You're not my kind of buyer. You put a contract on every single house.
No, not all 10. I'm just saying every time we found one that we liked, it was like about 10 that we would see, and then I was like,
Okay, all right. You're my kind of buyer then.
Yeah.
Okay, cool. Some agents show like 30 homes.
Hold on. So for every 10, you find one that you want to put a contract. So So why you need to go to the next time if you already applied?
Because they didn't agree to
Because
it.
both parties had agreed.
Why?
There was an offer and acceptance.
Because your agent did a bad job, man. You got to get a good agent, man.
Do you need a realtor?
That's what we're trying to tell you.
It's always, you know how it is.
I got
You
a
know,
couple of those already.
the best will in the
Joe,
judge.
I don't want you to lose this
The
one.
best realtor in the thank you very much.
The best will in the judge is right here.
Thank you very much.
$12.
Featured in Top Agent magazine, that's why.
You gotta show it on the camera.
Oh, give it to me, I'm gonna post in my Facebook.
Excuse me?
There you go.
Alright, from now on, you know who you're gonna see properties with? Him.
Just kidding.
Mm-hmm.
You better not,
Tá
you
vendo?
said it.
Ficou com ciúmes.
It's an oral contract.
This is jealous things, you know, did this.
Yeah, you got 5 pages.
Traded like that.
Yes.
Alright. Alright, gotta step up my game then. Anyway.
He doesn't blink.
No. Alright, at the bottom it says, because the broker agent has a monetary interest in the transaction, the buyer could void the contract if this fact is not disclosed. What are we talking about? Disclosed dual agency. If you want to write that there. Disclosed dual agent. What does that mean? You're representing both parties. Or also transaction broker, because you're representing neither one of them, but you're still getting paid. So both parties must be aware of how you're participating in this transaction, what they can expect from you. Okay? New Jersey also requires at the top the following language appear in exactly this form at the top of the first page of a sales contract. And you could go to the next page, and it says, this is a legally binding contract that will become final within 3 business days. So what I want you to do is underline, double underline, triple underline business.
Put star test.
Put stars, put circles,
Everything
put
is
bubbles.
business days.
Huh?
Most of the stuff is business
No.
days.
It's not. Lead-based paint was 10 calendar days,
That's the
for
only
instance. No.
one.
Off-site disclosures for new construction was 5 calendar days.
Alright.
You want more?
No.
Time is of the essence. Right?
Times it, yes, that depends on whatever they agree. It's whatever state. There's no standard on that one. These are standard.
Usually they put a date on it.
Usually put a date. They don't give you business or not. Yeah. But it could be business. It could be, the reason why I'm telling you to focus on business days is because that could be a question. If you put, like I said in the example with the monies, you get the money on a Thursday. When must your broker deposit that money? Right? Is based on business days. So Saturday, you got it on Thursday, Saturday, and Sunday don't count. That makes sense? That's why you got to pay attention to the difference between business and calendar. Okay. Speaking of which, if you're about to get suspended, or if your license is about to get revoked, how many days? Yeah, about. How many days do you have to show up in front of the real estate commission and appeal the decision?
30 days. 30 calendar days.
Nope.
Wait, repeat the question. Sorry, one more time.
You have a right to a hearing or a notice of hearing to show up in front of the real estate commission and say, I'm sorry, or whatever it is. How many days do you have?
7 days?
10 what?
Business days. Calendar days.
Calendar days, you see?
Easier.
Yeah, I didn't let you finish. I thought you were talking about
I knew it was 10, but
Yeah,
that's
finish.
You gotta let me finish.
Yeah,
It's
let
the
you finish.
same thing with the questions on the
Hey,
exam. You
John.
gotta read all the way. I'm dead serious. The only reason why people don't pass is because they don't read.
And sometimes they don't know.
Then what were they doing in class?
Oh,
But I can guarantee you that most of the people, most of the students that I have, when I tell them to read again, to redo the exam and now read this time and go with your gut feeling, get it done out of the way, I'll tell you, 90% of the times they pass the second time around. The first time that they fail, most of them tell me exactly the same thing. They did not read properly. If you speed read, you fail. Unless you're good, like him, at picking the right answer without knowing what it is.
C? No,
C or the longest one?
I know. I know
What
it's
do you
technique
what
already.
does mean C?
A, B, C, D. Just pick C.
No, I said, but why are you saying that, no?
Because C is correct.
it's always
In
easy.
school,
There's
that's how
always-
it used to be.
okay.
Just pick C. It's always correct.
But it doesn't work
No,
like
for
this.
sure.
No, it doesn't. It doesn't. It's just me. Us. We're messy.
This is a joke, right?
It is. If it's not C, it's the longest one.
This is true.
What was it?
No. It's not. It's not always.
Not all.
She's about to go there. Like, the
She's
longest
about to
one.
go there. You know what? I don't need these hours anymore. I'll just pick C or the longest
Let
one.
me take the tape measures, just make sure I have the longest one.
The longest question. Anyway,
It's gonna be fun.
it is. So, contract will become final within 3 business days, right?
Mhm.
During this period, you may choose to consult an attorney who can review and cancel the contract. That's what it is. So, attorney review, put stars next to it, in big capital letters right there, attorney review. It's where the attorney studies the contract, right? Starts counting the time from the moment that both parties received a signed copy. That's very important that you know. You count the 3 days from the date of delivery of signed contract to the buyer and to the seller. Because me, again, I mentioned this earlier, me putting an offer and you tell me that the seller accepted doesn't mean anything to me because I haven't seen the seller's signature. The moment I received my offer back with the signature, now starts counting the 3 business days. Okay?
Mhm.
And what happens during these 3 business days? Attorney study, and they have to issue a notice of disapproval to any of the terms within those days. And that's where we start going back and forth. So that's where attorney review starts. We never said it ends. Okay? It could happen. We've had attorney reviews that end in minutes. The fastest one I had was 45 minutes.
Wow.
But then again, you got to deal with real estate attorneys versus, I've mentioned this before, right?
Yeah.
Mhm.
Versus litigation attorney that spend most of the time in court versus real estate in the office, right?
Yep.
So, very important that you know the attorneys you work with and advise your client of that
So attorney review starts
within those days.
within
But
the-
it's not mandatory.
What?
The attorney review, right? You don't have.
The attorney
to.
review, no, the time period is mandatory.
Oh, no. But the attorney review.
Do you review with an attorney? No.
Right.
But you got you yourself can be your attorney and say within those days, you know what, I'll back out of this deal right now. Within those days. Okay? Beyond the 3rd business day, you're done. Now it has to be based on contingencies. You don't get approved for a mortgage, inspections, appraisals, all that stuff. Okay? But as far as contract terms, that's what it is. All right. At the bottom says federal requirements. You guys know this, right? The buyer of residential property constructed before 1978 must be offered what? What happened in 1978?
lead.
Lead-based paint was banned.
It was the first chapter. No,
No,
second one?
3rd chapter.
Not even. It's probably the 4th day, not the chapter.
Oh.
It was chapter 9, when we talked about EPA rules, where we talked about lead-based paint, carbon monoxide, radon, urea formaldehyde,
Mm-hmm.
right? Mold. Yeah.
It's your worst enemy.
Listen, I know the book inside out. I know the chapters. Makes a huge difference. Okay, so don't go by what I say in terms of like being quick to pick the information. When you review, you'll get it. You don't have to know if that was chapter whatever. No. You ask me, I'll tell you where to go. So again, if the property was built before 1978, you must, this is federal. State also has something similar, but this is federal. Every state goes through this. 1978, lead-based paint was banned, so you got to give a disclosure in the contract and a pamphlet about lead-based paint and the dangers for your family, right? But also, you got to give them a 10-day. See how it says 10-day, not calendar, not business? It says 10-day. If it says 10-day, then it's a calendar. Very good. On the right-hand side on top, it says contract forms. Contract forms. It says printed forms are used for all kinds of contracts because most transactions basically are similar in nature. That's the reason why we have 1 to 4 family, right? Standard contracts, because there's a lot of 1 families, 2s, 3s, and 4s. Anything above this is not, well, you could deem it commercial. What I'm saying is it's not normal. You don't have as many. But single families, a bunch of them, right? 2 families, a bunch of them. 3 families, a bunch of them. 4 as well. So that's why it's a standard contract. But there's still a problem. Because it's standard, are all houses the same? Are all buyers and sellers the same?
No.
Are all types of financing the same?
No.
So it raises three problems. One, what to write in the blanks. That's why your broker should have a very good training on how to prepare contracts. Because a lot of mistakes are made then, at time of preparation of contract, and they screw up the whole deal sometimes a few weeks later. Sometimes at closing. Because you did not write something in the contract that was essential. And then you can get sued for not including whatever the client wanted. Okay? The other one is what printed matter is not applicable to the particular sale and what can be ruled out by drawing lines through the unwanted words. For instance, if you're right here in Newark, do we have wells, private wells?
No.
Probably not, right? I don't think so. But you have to know. But there's also the Private Well Testing Act. You guys remember that, Chapter 9? Private Well Testing Act. If there's a private well on-site or off-site, you have to provide a copy of the water testing to both the seller and the buyer or landlord and tenant. And closing cannot happen until that is given. You guys understand?
Mm-hmm.
So obviously if you're in Newark and the property does not have a private well, do we need to check that box?
No.
No, it does not apply. So that's what I'm trying to say. It's a standard contract, but some things apply, some don't. And also, what additional clauses or agreements called riders are to be added? Luckily, we are blessed with technology nowadays. So if it's an FHA purchase, the person has an FHA loan, right? There's a checkbox that says FHA. You click on that, and it prepares for you the FHA addendum. Okay, so it's a separate page. It has nothing to do with the contract, but it's a rider. It's an addendum that talks to the seller of what an FHA is and what they can expect. Do you guys understand? And also to the buyer, seller and buyer. But do you understand what I'm saying? These are things are additional. If the house was built before 1978, you check the box. Guess what pops up? Disclosures about lead-based paint. You got it? So luckily we're in technology age because not too long ago, and some people still do it on paper, but then you forget those forms. Okay? So that's where the problem is with standard stuff. Speaking of typewriter, all changes and additions usually are initialed by both parties. We spoke about this,
Yes.
right? If changes are made, the rule is that typing takes precedence over printed form and handwriting takes precedence over typed changes. So there's a standard, you type stuff into it, but then once you print it out, you want to make changes, both parties must initial. Got it? So handwriting takes over everything else. Right? Was that on the test?
Oh yeah.
Damn, that was like a powerful, oh yeah.
Oh yeah. That was on the test. I got that wrong.
I don't know why I stopped these. I keep on questioning myself as I go. Why do I stop on these stuff?
Because there was no questions that he remembers, remember?
I
No,
thought he was going to throw something at you.
Smaller pen. Oh no, there's multiple pens.
Anyway. All right.
No, but
Listen, this is called experience. I know the questions. And again, I usually ask students whatever they remember. Some just black out, but whatever they remember to let me know. And as we're going through, you're actually helping because you're saying this is on a test, right? So if you guys pay attention when you go take the test, hopefully
think of shingles.
you think of shingles.
Start chuckling.
Imagine somebody in California goes like, "Thank you, shingles." The agreements, we spoke about them. Buyer brokerage agreements, we spoke about them in previous chapters. Transaction brokers, spoke about them. Sales contracts. In front of sales contracts, I want you to write offer equals offer. See, here's the thing. Somebody says, I want to give $1 million for this property, as an example. Put an offer. What they're really telling you is prepare a contract. All right, it says right there in the middle, depending on the locality, this agreement may take one of a number of forms and be known as an offer to purchase, please underline that, a contract of purchase and sale, earnest money agreement, binder and deposit receipt. So any of these terms means offer or sales contract, okay? Cool. Offer acceptance, you guys already know what it is, but right there in the middle I have a highlighted where it says any attempt by the seller to change the terms of they're proposed by the buyer creates what?
Counter offer.
Counter offer. So if it creates a counter offer, do we have to accept?
No.
So if there's a counter offer, what just happened to my offer?
Yeah.
So what does that mean?
Void.
Yeah, it's not.
It was rejected.
Right.
Reject, yeah.
So it's void. Yes, right rejected. Counter offer, right rejection. Where it says counter offer, somewhere there, right rejection. And the reason why I'm telling you this, in the exam there might be a question where the buyer put an offer of $200,000, but the drapes have to be included.
You can reject it.
Wait. 200,000, but I want those drapes. And I'm telling you, the question is going to be with something as ridiculous as drapes. Okay? So 200,000 with the drapes. Seller says, I accept your 200,000, but not my precious drapes. Does the buyer have to accept?
No.
No, because his offer was rejected. The buyer can walk away. That's the answer. Walk away, because there was a rejection. Yes?
Yeah.
You got it?
Got it.
Remember that. Earnest money deposit. Earnest money deposit. What is that?
Deposit that you take.
That you take or that you give, depending.
Well, yeah, whichever.
Okay,
Is
so
that the good faith?
good faith deposit. So write good faith deposit, even though it's written there, but I want you to write good faith deposit. Or if you want to call it security deposit, because it's the same thing as in a lease. You give something saying, hey, I promise to abide by this contract. The difference is that one is for a couple of weeks, the other one is for a year, for instance, right? But it's still the same thing. If nothing changes, you get your money back, or it's counted towards the offer in this case, right? So it says right there, it's highlighted, put stars. It just gives evidence, we spoke about this earlier, just gives evidence of the buyer's intentions to carry out the terms of the contract. All the way at the bottom it says any cash deposit of $10,000 or more must be reported to who?
IRS.
IRS.
You don't need to roll your eyes. Uncle Sam loves you.
No, I don't like it.
You don't like Uncle Sam? Don't worry, he doesn't even know you. Signature of a witness is not essential for a valid contract. Do we need to have a witness when we come up with a contract? No, it's not essential. So underline, not essential. Because if I ask you, what are the 4 essential elements of a valid contract, what are you going to tell me? That's what you're going to tell him?
Yeah. But you have to be 18 or older,
And that is called competent parties. Yes.
then you have to. I know, it's
and,
just
and,
simple.
and as soon as it's
All right, will you marry me?
no
Rejection.
offer and acceptance.
Offer and acceptance. Thank God you said no.
It was a definitive no.
Right?
I thought he was gonna say yeah.
Careful.
Careful. He's shingle.
Offer and acceptance. Competent parties. There's consideration.
Consideration and
And
Like legal.
legality.
legal purpose. All right. Yahtzee. You got it.
Yeah.
Good. So signature of a witness, if that's one of the answers in the question, right? Is it essential?
No.
No. So you look for the other options.
I didn't get that question.
The question could have been all of these are essential elements except. Boom. Okay. On the right hand side, it says among the common provisions in the subject to section of the contract are the purchaser's need to secure a specific loan. I told you. We got the 3 business days and it becomes binding, right? After that, if you don't get approved for a mortgage, it's one of the contingencies. I'll buy it subject to approval. If I don't get approved, do we have to proceed? No. So when do you think it should be good to get an approval?
Before.
Before. Is it guaranteed?
No.
Nothing's guaranteed. All right? But if you don't even have that, then what's the point of starting a contract? Just saying. Also, it says the purchaser's right to a satisfactory report on the property by a licensed home inspector within a specified few days. Satisfactory, what does that mean? That I look at it and I agree with it. I'm satisfied with what's there. Okay? It says approval of the contract by a family member, again within a short period of time. Hey, listen, I like it, but I got to talk to my wife before I make this decision. Right? That's why you should have the decision makers Does that make sense?
Yeah.
And a lot of investors, I'm just giving you a warning right now, a lot of investors play this game. They go there, put offers, I gotta talk to my partner, right? And guess what? They go home, they look at the mirror, talk to themselves, because that's the only partner. But it's enough to evaluate what they need to evaluate and then cancel your deal. So be ready for that. You got it?
Mhm.
Your partner should have been here.
Yeah.
That's all. Okay? That's why you should always, when you talk to them, no offense, but are you the decision maker? Or is there anybody else that would contribute towards the decision on this? Is there any way we can have both see the property? Always try to eliminate these contingencies. The problem is when they have to talk to their dog also. So.
Very nervous.
It says the buyer cannot be required to complete the purchase if any such contingency is not satisfied. Make sure you underline that and put stars. If it's a subject to, then we put contingencies, and contingencies are conditions. I will buy if these conditions are met. If they're not met, I don't have to buy. Very important. Where the purchaser has one home that must be sold first, the seller may insist on an escape clause, also called kick-out or knockout clause. So here's the thing. I have to sell my house in order to buy yours. Now, are you going to wait until I sell my house? No, you're going to give me a fair period of time to sell my house in order to buy yours. Fair, right? But then you're going to include what's called the escape clause that says, hey, it's almost like the time is of the essence. Like, hey, you're taking a little bit too long than I expected. If we don't close, if you don't step up and close within the next few days or weeks, whatever we decide, then I'm backing out of this deal. I'm selling it to somebody else. You got it? Next page, we have liquidated damages. Do you see it? Liquidated damages. What was liquidated damages? You guys remember that? What were liquidated damages?
We just went over it, Jim.
Yes, write settlements, please. Settlements. If the buyer backs out of the deal with no legal excuse, the seller can retain the security deposit. Think of it as a tenant. If a tenant does not fulfill the agreed upon contract and damages the property or fails to pay rent, what can the landlord do? Keep the security deposit. Here, if the buyer does not do what they were supposed to do, the seller can keep the deposit. That's liquidated damages. I have it highlighted. The seller who does choose to keep the deposit as liquidated damages, please underline, may not sue for any further damages. It's liquidation. This is what we got, and that's it. Okay? Good news. Remember I said you don't need an attorney to prepare a contract or move forward with a contract? Great. Plain language requirement. Because of this, the agreements for the sale or lease of residential property must be written in a clear and coherent manner with words that are common in everyday usage. So if right now you were to read the contract, you should be able to understand without the need of an attorney. Should you have an attorney? But should you?
Yeah, you should.
Absolutely.
Or advised.
Be advised by an attorney, yeah. Okay? Option agreements. If it's an option, what do you think we have here?
An option.
To what? To something, right?
Whatever's in there.
In front of it, you're going to write, similar to car lease. Have you ever leased a car? Do you know what a lease car is?
Yeah.
Yeah.
It's where you rent it for long term, and then at the end you have the option to
Bye.
Buy now.
buy. Do you have to buy?
No.
No, because it's an option, underline option. You got it?
Yeah.
That's why it's similar to a car lease. You put an offer on a house that says, hey, I'll rent from you with the option to buy. It's rent to own or lease with the option to buy. Okay? At the end of the term, like 3 years, let's say, I'll decide if I buy or not. So you're kind of like test driving the house, the neighborhood, and all that stuff. You're trying to figure out if this is where you want to be. Okay? You can. It's just negotiate with landlords. Anyway, that's how I started investing in real estate, was options. So.
Okay.
Land contracts. I want you to write similar to car financing. When you buy a car, and you finance the car.
Mm-hmm.
When do you get the title? Not in this
When
case.
you pay it off,
You get the title when?
when you finish
When you
paying.
pay it off, right? So it says right there in green, all the, in green, sorry, you don't have in green, so highlighted. It says, although the buyer obtains possession, just like a car, you get possession when the contract is signed by both parties, and the buyer has something called equitable title. That means you put equity or money into it, right? The seller does not execute and deliver the deeds to the buyer until, please underline, the terms of the contract have been satisfied. Similar to car financing. You pay, right? And then at the end, they send you title. So option agreements, similar to car lease. Land contracts or installment contracts are similar to car financing.